we are aware that this is something which was a very important question of law that was raised before the NCLT. The NCLT had very diverse views on this, where the some of the members felt that the Noida cannot be considered as financial creditors, while the others were willing to give it that benefit. And ultimately, any which ways, the matter went before the appellate tribunal. And the appellate tribunal also agreed that it is not a financial creditor, and then that is how it ended up in Supreme Court. Well, the facts are not really relevant because we are not really discussing this in the context of the facts of this case, which are very typical. That the Noida, Yeda, most of these authorities in different parts of the country which have given lands on lease for various projects based on the very clear judgments that are there from the Supreme Court in the early days of IBC have been filing their claims as Form B. In some cases, they've also attempted to file Form C. And in many cases, like the one which went before the Supreme Court, initially the Noida Authority had filed Form B and then subsequently changed it to Form C. Well, any which ways, they did not succeed before the NCLT, and I'm glad the matter came before the Supreme Court. Now, there were, before I go to the slides, I just want to sort of lay the context in a very simple terms. I won't be very technical about it, although the judgment is, although very beautifully written, but I do believe that the judgment, the flow of the judgment could be, I wish, something similar to some of the other judgments that have come out, which is that easy to understand by the lame reader, by a common man. Especially, I thought there would be subheadings which would deal with the various provisions of the Indian accounting standards, their context, their interpretation in terms of the definition of financial creditor and the financial lease. But having said that, I mean, even I had to read it 3-4 times before I got a grip of it to the extent that I believe I have been able to. I'm not saying that I fully really comprehend it, but yes, I mean, at least took me at least 3 readings. And the 4th reading happened to be this morning when I was preparing for this talk very briefly. Now, as I understand the judgment, what the Supreme Court was called upon to interpret was the definition of the financial creditor, financial debt, as given in section 5(8) of the IBC from 3 particular dimensions or through 3 different prisms. The first was the inherent definition and meaning of the financial debt as it appears in the main definition, and the fundamental aspects of it, without really deep diving into the subclauses. The second was, of course, which was the key issue which was raised in this, which is the clause D of 5(8), which talks about the financial lease, which is what one of the main cases of Noida was. But the third dimension, interestingly, which also the lawyers who argued on behalf of Noida relied on, was the clause F, drawing from the judgment of the pioneer. Now, I will take it up one by one, all the 3 dimensions as to how the Supreme Court has dealt with it, and I'll keep it very, very simple, not talk in terms of too much of technical expressions that appear, although I'm sure all of you do understand the technicalities of that as well. But for me, I think one of the most important aspect was that Noida Authority was arguing on these 3 different prisms or dimensions as follows. as far as the main definition is concerned, under section 5.8, which provides that a debt along with interest, if any, which is disbursed against the consideration of the time value of money and includes, they were arguing that you have to read the disbursement to mean and include both ways of disbursement. It doesn't have to be from the creditor to the borrower. A disbursement by the borrower or the debtor to the creditor would also fall within the definition of and the meaning of the word disbursement that appears in the first part of this definition of financial debt. And they, in order to do that, they relied on the word transaction that appears in the definitions, which is in the section 2, not in the section 5, which actually talks about what the transaction includes and what the transaction is all about. Of course, that was rejected by the Supreme Court, and I'll come to that in a moment, the reasoning of that, part of it you see on the slide itself. The second thing, of course, they argued was that when I talk of section 5.8d, they said, for all intents and purposes, we are a financial lease and we qualify within the Indian accounting standards. That argument was also rejected, but I'll come to that in a moment. And the third part then, of course, as a last straw to hang on, they relied on the clause F also, as I was mentioning, relying on the pioneer judgment. As a pioneer judgment to say that even in pioneer judgment, the home buyers who are not really a creditor per se have been held to be creditor, even though they pay the money. It is not that the corporate debtor has paid the money borrowed from them. They paid for a different purpose, but it has been held, although in the context of pioneer, and therefore they said that the same principle should be applied here, which also was rejected by the Supreme Court. And I'll discuss all these three parts. But let me just discuss with the first part, and I'll share my views on this also. I also had the opportunity to assess the NCLT in 3 cases as whether the Noida is a financial creditor or not. And I obviously was, in all the 3 instances, arguing against the Noida proposition. I was arguing in favor of there being an operational creditor and not a financial creditor. Now, if you see what the Supreme Court did not appreciate in Noida's argument was when they reiterated for the first time in this particular context, but had already been settled in the J.P. Kensington Anuj Jain's judgment. And I'm quite surprised that Anuj Jain's judgment was not relied or referred to at all. But Anuj Jain's judgment is the first case where they have actually, in much greater detail, laid down the whole concept of financial creditor, difference between financial creditor or any other creditor, a difference between why a financial creditor is so fundamental to the very genesis of the business, and therefore why it gets a primacy in the whole scheme of the code. Why is it that the financial creditor therefore gets to sit on the committee of creditors, but not the other creditors who may otherwise be of significant value, except of course where the operational creditor's debt is of a particular value, as you know, more than 10% and things like that. And I'm quite surprised that they did not refer to that judgment at all, because that's where the real principles were laid down. But having said that, they did reiterate the same principle. And they held 3-4 very important things while interpreting section 5.8 in the context of whether an entity like Noida would be treated as a financial creditor in respect of any dues that may be arising out of a lease which they have executed for the land, and any dues that remain unpaid from that. Now, the first thing is that they said we recognize and we do not dispute that there is an existence of a debt, and the debt that arises from the lease is a debt within the meaning of the code. They also said, and which is something which is said in a byliner though, as 2 lines on which, although there is a full-fledged judgment of enclave though, they said that even though there is no liability to pay interest, or that it was not, whether it was envisaged in the lease or whether it has become due and payable or not, or whether there is a liability of interest claimed or not, the fact is it is immaterial. They say as long as there is a debt and that payment of debt was without any liability to pay interest, it would still constitute a debt within the meaning of section 5.8. And I think this is the first judgment of that. Is although it's one line, they haven't discussed in too much detail, but it is going to be of implication in many cases. It does affirm the enclave view already taken in a couple of judgments. The second very important thing that they mentioned was, and this will have a wider implication in other cases as well, where they say that the word disbursement that appears in section 5.8 first part only constitutes and refers to a disbursement which is made from the creditor to the debtor and not two-way. And they, in order to hold that, they interpret the meaning of the word transaction, which appears in section 233, which was what the Solicitor General, Assistant Solicitor, Additional Solicitor General all had relied on, to say that you have to have a constructive, harmonious reading of the 2 words, transaction and disbursement. And a transaction can always have a two-way flow of the money. It doesn't need to be only one way flow of the money. They considered it and they rejected that argument to say that while in any other transaction, yes, it is true, but to import the meaning of transaction into section 5.8 for interpreting the word of disbursement will be incorrect, because it will expand the meaning of disbursement beyond what the intent of the law is. This is what they say pure and simple means a disbursement that is made against the consideration of time value of money, and includes, of course, the following as fall from A onwards. So this is again a very important reiteration, because what had been argued repeatedly in a number of cases is that the expanse of the word disbursement cannot be restricted to actual disbursement by the creditor to the borrower, because if you see from clause A to H in section 5, subsection 8, there are various forms of transactions which are illustrated there, which may not necessarily involve disbursement of money per se. But they say that those have to be tested. The Supreme Court says those have to be tested wherever somebody is claiming to be a financial creditor on the basis of the category from A to I that they may fall in. But for the purpose of reading section 5.8 main definition, the disbursement has to be one way. It cannot be read to be something which would be read to be as something which could be a reverse flow as well, which is what they were alleging in this case, because they say that because the lessee has paid an amount in consideration for the lease, whether in the form of the lease rental or the premium, this amounts to there being a transaction, and therefore you should read the juxtapose the disbursement against the transaction. Now, it's a bit of a complicated thing, but the Supreme Court simplified it by saying that we're asking too much. This is not how we see it. And I wish they would have relied on the JP judgment to reinforce this point. But anyway, they just left it at that. And therefore, they held that as far as Section 5, subsection 8 main definition is concerned, there is, in the case of Noida, no disbursement of debt by Noida. Although there is a debt, but that debt would not necessarily be mean as having been disbursed under section 5, subsection 8. Now, obviously, you can't read this finding in isolation. You have to read it in, together with the other two views that the Supreme Court has taken on the other parts of the definition, as I mentioned in my opening comment, and I'm moving to that now. Now, having done with this first part of section 5, subsection 8, where they hold that there is no disbursement of debt, which is a prerequisite for there being a financial debt, they move on to discussing as to whether there is a financial lease between Noida and its lessees. Now, this is a very important, interesting proposition, and as you know that the bench 4 in the NCLT had held, although in a very short, cryptic judgment, not very reasoned order, not much law had been appreciated, because there is a huge body of work, judgments on what constitutes a financial lease under the Indian accounting standards, although not in the context of IBC, but in the context of taxation and other issues. There are some judgments, and there are some judgments in the context of Surfaisi Act as well, because there is a judgment, there is a definition of Surfaisi, which appears in the Debt Recovery Tribunals Act, though, but Surfaisi adopts the same judgment, same definition. So this judgment of NCLT, though, was upheld by the NCLAT by giving its own reasoning, and I think that was a much better written judgment. But ultimately, of course, it went to the Supreme Court. Supreme Court has also examined this. Now, let me just share with you what the Supreme Court says and how they test this. Now, what is the most important thing is that the first thing they said that we will, since there is a definition of financial lease, or what will constitute a financial lease in the IBC itself, that is 5.8d, we will not look at the definition given under the Surfaisi or the Debt Recovery Tribunals Act, because that would be a flawed approach, as we have the definition in the code itself for us to interpret. Now, then they looked at the definition. The first argument of Noida was, and this again was quite a strange argument though, but I'm telling you in a very simplified way, because the clause D reads as follows, and I'll read it for your benefit in a moment. It says, the amount of any liability in respect of any lease or hire purchase contract which is deemed as a finance or capital lease under the Indian accounting standards or such other accounting standards as may be prescribed. Now, what Noida said was that two things. They said there is a word deemed appearing in this definition in clause D, and therefore there is a deeming fiction that every lease or hire purchase contract would be deemed to be a financial lease. That was the argument. They were saying that you have to read the deemed word to mean that it has to be read with the first part of the clause D and not with the second part of the clause D. And they also said that you can't just look at Indian accounting standards only, you should look at other accounting standards like international accounting standards. So the answer to that by the Supreme Court was very clear. What the Supreme Court said was, this section very clearly says that you have to rely on Indian accounting standards. Since the Indian accounting standard deals with it, which are framed in the section 133 of the Companies Act, And there are no other accounting standards prescribed under the IBC for testing this definition. Therefore, we will not go to any other accounting standard. We will look at Indian accounting standard only. As far as the deeming provision is concerned, they very clearly said that the deemed word here has to be used as a verb, meaning therefore that every lease or hire purchase cannot be deemed to be a financial lease. Only those leases or hire purchase contracts which have to be, and they relied on this word, that will be deemed as a finance or capital lease according to the Indian accounting standards, which means that it is the Indian accounting standards which will determine whether it is a finance or capital lease. That is where they said the answer lies. So therefore they said every hire purchase contract and every lease is not a financial lease. Only those hire purchase contracts which would constitute a finance or capital lease in the Indian accounting standard would be deemed to be the financial lease. That is what it is held. And they therefore rejected the argument of Noida that deeming provision has to be read as to mean that every lease or hire purchase contract will be deemed to be a financial lease. That argument was rejected. Now, this was, of course, the most simple part. And I don't really think that Noida was even serious about arguing this proposition, because from what we had experienced in NCLT and NCLAT, Noida was more reliant on the terms of the Indian accounting standards to support their argument. And in one of the cases, they had even got an opinion from a leading advisory firm, a tax advisory firm, which held that it is a financial lease. But that was not accepted by the NCLT, because at the end of the day, it was only an opinion by one of the advisory firms of the country. And the court was entitled to interpret the provisions on its own. Now, let's move to the second leg of this financial lease aspect, which is where Noida argued very, very aggressively. Now, if you see, I mean, these are the accounting standards. You've already read about that, so I'm not really going to go into that in too much of detail. I will refer to them wherever required if I need to come back to them. I will straight away go to what the analysis of the judgment of the Supreme Court was on the Indian accounting standards and their applicability from Rule 61 to 67. Now, what the Supreme Court noted was that the Indian accounting standards require, and these are not just one of the tests that need to be satisfied. These are multiple tests that need to be satisfied, which collectively will make it a financial lease. Not that you need to be able to satisfy any one of the rules. Although that doesn't really come in too much of explicit words in the judgment, but that is what I think the judgment implies, because it does test each of the rules very, very clearly, and as to whether Noida falls and qualifies all of these or any one of these. And I found that they held by and large that either the Noida doesn't fall in any of these, or to where it doesn't apply to Noida at all. And we'll discuss that in a moment. So now they said that the criteria for the determination of the fees for the financial lease has to be as follows. The first thing they hold is that there should be a transfer of all risks and rewards which are incident to the ownership of the underlying asset. Now, the first question that arose was whether there is therefore ownership which is transferred to the lessee, because the risk and reward, the question of testing that would only arise if there is transfer of ownership in the first place. If there's no transfer of ownership, there is no question of there being any transfer of any risks or rewards. So after going through the various terms of the lease deed, the Supreme Court noted that it was at best a lease for 90 years, and after 90 years, the land will revert back to Noida. There is no transfer of ownership. And in fact, even if there is an asset that is built on the land, or if the land is together with that asset or without that asset which is built on that in the form of building or structure is transferred to a third party, even that transfer would be treated as a sublease. It is not a sale in so many words. No ownership gets transferred to the sublessee also. The second thing that they noted, which was also the requirement, it is also the requirement of accounting standards, is that even if there is no transfer of ownership, there should be or should have been an option with the lessee to purchase the asset, the underlying asset, during or at the end of the term of the lease. And the Supreme Court held that even this term does not exist, which is one of the requirements, I think, of Rule 61. And therefore they said, one, there is no ownership of land. Two, there is no option on part of the lessee to purchase the land. And therefore, this requirement of the Indian accounting standard is not satisfied. So what Noida did was they moved to an alternate argument. They said, okay, fine. The land may not be transferred, the ownership of the land, but the fact is that the building which is built on the land, that gets transferred. And therefore, that is owned by the end user or by the corporate debtor, because the lessee as a corporate debtor or corporate debtor as a lessee receives all the risks and rewards incidental to the ownership of that asset which is built on the land, on the building and the structure. So Supreme Court then considered that argument in the backdrop of the provisions of the Transfer of Property Act, in particular Section 105 of the Transfer of Property Act, which talks of the right of a lessee to enjoy the property. And the Supreme Court held that the right to enjoy the property is different from the ownership of the property. These are two different things. So I may have a right to, as a lessee of the land which is leased to me by Noida, I may have a right to enjoy that property in the manner or for the purpose that the lease says, but that is different from the transfer of the land to me. And in Indian accounting standard, they said, we have to see the transfer of ownership and not the enjoyment of the property, as to how you enjoy it. And they also said that even the lessee, as per the lease, does not have the right to purchase or option to purchase the right to develop or construct the building, which is what may be the purpose for which the lease is granted, but I don't have the option to purchase that. And therefore, at the end of the lease, the property, together with the building and structure thereof, will go to Noida, irrespective who may have developed third-party rights on that. It is immaterial, because then they also refer to the various terms of the lease, which very clearly say that you will have to give the land back in such way that it can be used again by Noida. Now, so therefore they rejected this argument also of Noida. Then Noida argued that even if the title is not transferred, the majority of the economic life of the leased land is used by the lessee. And this, as you all would know, is one of the requirements of the Indian accounting standards for a lease to qualify as a financial lease, that there has to be an element of transfer of the economic life of the underlying asset. Even though the ownership of the title may not transfer, but the economic interest should be perpetual in that sense. Here, the Supreme Court held, and rightly so, of course, that as far as the economic interest in the economic life of the lease is concerned, in land, it is inapposite. The economic life of a land never gets exhausted. So it is not that when the lease period of 90 years ends, the economic life or value of that lease also comes to an end. In fact, the Supreme Court noted that invariably, in the case of land, the value will only increase and not decrease, ordinarily, of course. So one can't say that since 90 years you have used this land is now dead. It is not like a mine where you have mined the mineral for whatever period of lease, and therefore after the lease is over, you have mined the entire wealth out of it. Obviously, that land will not fetch the same value which it had when the mine was leased, because the value of the mine was determined on the basis of the minerals that existed under it. And when they have been exploited, when they have been extracted, and when it has been sold and only a barren land is left, then obviously it will not hold the same value. But this is not the case where the lease of the land is given to build a structure on that, irrespective whether the structure is built or not, whatever that structure may be, it will get terminated with the termination of the lease, and the land would still exist to be used afresh for whatever purpose, even though it may require the demolition of the structure thereon. And that also is in some way implicit in the lease deed terms also. I'll come to that in a moment. The Supreme Court also noted that even though the transfer to the end buyer, it could be the unit holder as a commercial unit holder or the residential unit holder, when you execute the sublease, it is termed as sale deed. You register it, you pay stamp duty, and for all intents and purposes, it's a transferable title. But yet, what they noted was that you would still call it as, I would say, a sublease. You would still, as a sublessee, not be able to transfer more than what you have acquired from the lessee. Similarly, the lessee cannot transfer more than what it has got from Noida. And also there are some terms where the mortgage of the property cannot be done with the prior approval. So there are a lot of strings attached. And that being so the case, I do believe that one would come to the conclusion that the economic life is not lost. And in fact, the Supreme Court discusses in about 7-8 pages various terms of the lease deed, standard lease terms of the Noida, which clearly show that ultimately when the land reverts back, it should be in good usage form, which means that, although not specifically mentioned, the Noida would be entitled to say, although we haven't really seen the light of the day for that for 90 years, because we haven't really seen a case where 90 years have already passed. That's anybody's guess. But the fact is that there is a right that Noida have inbuilt into the lease to claim that if after 90 years, I would have the right to get it back, to be able to use it in the manner that I wish to. which could be different from the purpose for which it was first leased for 90 years. The other issue, which is, if I may say, was a little bit of more complicated. I want to just mention whether I just want to see whether I missed one point of secondary. Okay, that maybe is going to come later. So that's more of a value issue, where the lease actually, one of the terms in the Indian accounting standards provide that it will be a financial lease only if at the inception date, the present value of the lease payments amounts to at least substantially all of the fair value of the underlying asset. Now, what the Supreme Court notes is very clearly, as per the Indian accounting standards and the law, and generally, the inception date is different from the commencement of lease. And the lease deed does not in any manner say that the inception date is the same as on the commencement. And in a way, therefore, they say that the lessor itself has not classified the price into two categories. And what they say is that as per the lease, the value is calculated on the commencement date. And on the commencement date also, only 10% is required to be paid, and the rest is, of course, spread over a period of years. And therefore, the Supreme Court said that this requirement of the Indian accounting standard is also not qualified, is not satisfied, because the 10% does not represent the substantially all of the fair value of the land. And they also said that just because the premium is paid, that premium cannot be factored into the fair value, because that premium is paid for a different purpose. That is what the Noida argued, was that the lease is paid as the lease rental, and the premium is paid for the development rights that are given. And therefore, they say that you can't therefore say that the premium that the lessee pays is actually the fair value of the land. And that may be an economic exploitation, or as Section 105 says, usage of the land, 105 of the Transfer of Property Act. And therefore, they also rejected this argument of Noida, which I do believe, in my view, is something which is arguable both ways. I mean, this was one point at which arguably Noida was on good footing. The other point, of course, what was required as per the Indian accounting standards is that gains or losses which arise from fluctuation in the fair value of residual accruing a residual that accrues to the lessee should also be on lessee's account. And we all know that the residual value is defined in the Indian accounting standards, which is as it is quoted on the screen. Now, having interpreted that, the Supreme Court said that these ingredients are not satisfied, as the Rule 4064, which mentioned these, actually is an example given where the life of the asset comes to an end at the end of the term of the lease. Now, if you read in that background the definition on the screen, which reads as under, the residual value of an asset is the estimated amount that an entity would currently obtain from disposal of the asset after deducting the estimated cost of disposal, if the asset were already of the age and in the condition expected at the end of its useful life. So therefore, the Supreme Court said that this is actually something which will apply to an asset, an underlying asset, whose life comes to an end. I mean, like, for example, this could be an asset where there's a plant and machinery, which is as per the hire and purchase contract, and there's a class of plant, and as per that contract, or as per these accounting standards, the life of that machine is 35 years, 40 years. It may become obsolete in technology. It may outlive its life, its utility, and it may become non-functional. It can only be sold as a junk. It will not have the same value. But that test doesn't apply to land, because the life of the land doesn't come to an end, as has been mentioned by Supreme Court in the early parts of the judgment, which I also mentioned earlier. Now, this is very important, and I think the Rule 64 of the Indian Accounting Standards say that there should be an enabling provision for an extension of the term, which means the secondary term. If on the expiry of the original term, there should be an enabling provision where the parties can extend the term. And in this case, they found from the Noida's lease terms, there was no such provision. And 90 years is what is written as the only term of the lease. There is no provision, at least they found in the cases that were before them, where there would be an enabling provision for extension for a subsequent period, whether it's 90 years or lesser or more. Then there is also, of course, another term that they found as a requirement in Rule 67, though, after going through all the illustrations of Rule 64, which most of them they found as not applicable to the facts of the case. They also felt that Noida itself has never treated it as or classified it as a financial lease in their own record. And in one balance sheet, it was treated as a sale, but it was never itself classified by Noida. They felt that without saying so, that it was an afterthought. Noida itself has never really treated it as a financial lease. Now, having said that, let me just move to the last issue, because at the end of this, they concluded that it does not satisfy the tests and parameters laid down in Indian accounting standards from Rule 61 to 67 for declaration of a lease or a hire purchase contract as a financial lease, and therefore Noida doesn't qualify to be financial lease. And then, of course, also in about 6 to 7 pages, examined it in the context of clause F of the definition of financial debt to see whether the parameters that were laid down by Justice Nariman in Pioneer case, where the home buyers were held to be financial creditors, would also extend to the statutory authorities like Noida. And the Supreme Court, while of course rejecting that argument of Noida, primarily relied on the main definition of Section 5.8 to say that there was no transfer of funds, there was no disbursement within the meaning of that. In that case, the Supreme Court had held that this disbursement would mean a disbursement by home buyer to the co-debtor as well, while in this case, you can't stretch the meaning of disbursement to a lease rent payment. And therefore, they rejected that argument, although summarily, but they did rely. So now, before I go to Vidarbha, I want to really spend about 5 to 10 minutes on Vidarbha. I just have 2 observations on this. The Supreme Court also obviously felt that this is how the law is, we can't help it. But of course, it is for Noida to take corrective measures. If they want, they can make the necessary changes and ensure that their financial lease satisfies the parameters laid down in in Indian accounting standards. Now, this does create a lot of implications for Noida, and not just Noida, for a number of such authorities, state authorities, which give land on lease, where there's a Huda, Huda, we all know HSIDC, a lot of such agencies across the country. It does create a big dilemma for them, because we are now dealing with a situation where someone may not be a financial creditor, but which is very fundamental to the genesis of the project. Like a financial creditor gives loan for the project to take up on the basis of the project report. But here is a creditor or a party which has given land. Without the land, there would not be any project. And therefore, to exclude it from the definition of the financial creditor is a very bitter pill to swallow. But yes, on the basis of the technicalities of the law, on the basis of the letter of the law, on the basis of how it has been interpreted by the Supreme Court, they would not be financial creditor, they would be operational creditor. Now, what happens? No state agency would accept this treatment. All of them would, in one voice, do either of the two things. One, they would go back to their respective governments and say, amend the law, allow us to, or go to the finance ministry, corporate affairs ministry, and ask the IBC to be amended so that they are treated as financial creditor, or an adequate protection is given to them in their dues, in the payment of their dues. Two, alternatively, they will start now changing the practice and ask for all the payment to be made by the lessee upfront. They would not take the chance of the payments being spread over years. And rightly so, because this has potential of misuse also. Somebody takes on lease land, pays the first 3 installments, gets an insolvency petition filed, gets a resolution plan approved, and wipes off all the debt of the Noida. I mean, there is a huge potential of mischief and misuse. And at the end of the day, this is public money. And therefore, public money also needs to be guarded. While I do understand the principles which are inbuilt into the IBC, but at the same point of time, they are not meant to shortchange such creditors. Nowhere in the world would such a treatment would be provided to such a key stakeholder, which is so inherent and fundamental to the project. And therefore, I do believe that there needs to be a balance drawn. Because we also recognize that in the event the entire amount is to be paid to Noida or to such statutory authorities, no plan would ever be approved because nobody would have the money to pay or that kind of money to pay, because that may not really make the plan feasible or viable. Therefore, some obviously concession is required. Whether it is wiping the slate clean, or whether you draw a balance is something which needs to be discussed. And that's where, if they were to be treated as a financial creditor, then pro rata, same footing, or getting it in the same waterfall mechanism is something which can be discussed. And that's a discussion that we can have, maybe if you have some questions after that. I just want to spend now very quickly about 5 to 7 minutes on the other 2 judgments. Not on Vidarbha as much, because Vidarbha has been clarified and reviewed to say that it is it applies to the facts of that case. But I have to say that this judgment leaves scope for NCLT adjudicating authority to start flexing its muscles and to say we have more power. We just can't be rubber stamp anymore. We have to hear the case of the copy data on its own merits. And if we also have to see whether there is financial viability or not, even though in the facts of this case, the financial viability was being tested on the basis of some huge receivables that were in the pipeline through a pursuit and award. But in many other such cases, there could be a number of other equally convincing reasons where the corporate may plead, I am not insolvent as such. I have liquidity. That liquidity is blocked. I have a huge amount of receivables which would outnumber my debt. And if you give me some time, I would be able to service that debt. So it does create that kind of uncertainty. But I also see that the debate is very clear. I also see that the general mood in the market is that you have to ignore this judgment. Even the NCLT is not really following it so vigorously. But if this becomes a bit of a problem, I'm quite sure that the government would amend the law to, in some way, dilute the misuse of this judgment if they see that misuse happening. On this, I just want to mention 2 points very clearly. Not going to the slide, I'll share my slide with you. I mean, I think that to some extent there is an overreaction to rainbow judgment. I find only 2 paragraphs in that which definitely need to go. and the government has filed a review already, as you know, not the government, but a bank has filed a review. So hopefully it will see the correction. I find no difficulty in accepting the propositions on this screen, which is on the screen. First of all, irrespective whether the claim is filed or not by a creditor, if the RP or the IRP is aware of that claim from the books or the litigation that is pending, even though that claim may not be admitted to the books, that claim has to be entertained. That claim has to be included in the list of claims. The RP cannot say that I will not, just because the claim has not been filed. And I think if you see my book, which came out in 2017, I had very strongly argued in this proposition, the RP has to actually proactively reach out to all the creditors and has to make them file the claims. And if somebody doesn't even file the claim, you still have to include it as long as you can verify it from your books. That has now become the law. The second, of course, now it is also in the regulations. The second, of course, is that there is the timelines of filing the claims are directory and not mandatory. There have been two views about this right from the beginning. That again is something which we have swallowed as a spoonful of salt. It doesn't matter. If somebody comes in as late as before the COC approves the plan, or for that matter, if it is an insignificant claim which doesn't really cause any bearing, then even if before the RP, before the adjudicating approves the plan, as long as the claim was not entertained on account of the RP's flaw, not for the reason that the creditor was negligent, it should be entertained. Now, I also have no difficulty with the last bullet on this slide, which says that a tax department's asset would be treated as a security interest and therefore render the tax creditor as a secured creditor. No difficulty in that. I think they would be a operational creditor, which would be a secured creditor. That is what the law has been from the beginning. That status as a secured creditor may come from the statute or may come from a contract, a loan agreement, or a security creation document. That has been the law from the beginning, so nothing new as far as that is concerned. Now, I think the confusion arises where the Supreme Court sort of very similarly starts holding that they would rank equally. Now, I don't think the intention there is to say that the secured financial creditors and the security interest of an income tax department or any other such security credit holder would be treated as at par. I think what the Supreme Court means to say is that they would both be treated as secured creditor. But when it comes to making them payment, that has to be made as per the waterfall mechanism. Now, there are possibilities where the income tax may have, based on a debt it has become due to it, which remains unpaid, and it is entitled to recover it from the assets which are secured to it. If the income tax has filed its claim, its security interest with CERSAI and with the ROC, and that security interest is charged in favor of the income tax, then they will be treated at par with the secured financial creditor, but their priorities will be determined on the basis of the priority rules under CERSAI. Because CERSAI decides you may be secured creditor of the same asset, but who gets paid will be determined by the date and time of notice to the public under the CERSAI rules. So this is the only clarification that is needed. So as far as the first part is concerned. Now, what I think the only thing which bothers me is the two paragraphs in the judgment which say if the statutory dues are ignored, then you need to send the company into liquidation. That I think is completely contrary to the earlier judgments. And my sense is that in review, those would be corrected. And these are the two paragraphs which are the damaging ones. The rest can be clarified, is what my view is. There has been a bit of an overreaction to this judgment because of those two paragraphs. And I also would say to some extent of the lack of understanding of how an operational creditor can also be a secured creditor, how the priority rules are determined. Because what this judgment didn't do, unfortunately, was it doesn't discuss the judgment of the SR, Steel on Secure Transactions, SR. It doesn't discuss also the provisions under the CERSAI Act, which were introduced following in, I think, 2011, by way of an amendment where priority rules were determined for the first time for secure transactions in the country. And those rules apply as much to IBC, as much to DRT, as much to liquidation, and as much to SARFAESI sales. Now, once those are discussed and the clarity comes, I think that judgment can really be distinguished. I don't really see that part as a worry. Only 2 paragraphs are those that need to go all together. So I will stop here. I will be happy to take questions now or after my co-panelist has done. I will put my video on the silent if it is afterwards, but if it is now, I'm happy to take my questions now.
If anybody has questions, they may ask from sir on the judgment.
All right, maybe there's none at the moment. Maybe we'll wait. I'll put my video and mute. I'll mute my video and audio. I'll be listening to my co-panelists, and maybe at the end, if there is anything, I'll be happy to.
Thank you. Thank you, sir, for the session. Thank you so much. The next session will now be taken by our next faculty, Mr. Ravi Prakash Ganti. Mr. Ravi Prakash Ganti is the founder director of Resolve International Private Limited. He has corporate experience of more than 35 years across various industry sectors and functions. He has held board CEO level positions in 2 listed companies. He has been practicing as an insolvency professional since 2017. He is currently liquidator, earlier RP of a group of 9 CDs in real estate sector. He is an advisor to RPs and liquidator in various matters. He is a regular faculty in courses conducted by IPAs. So you may now start the session.
Thank you very much, Anu. Thanks a lot.
Thank you.
Mr. Sumant Batra is always a hard act to follow. And I can very well understand why there are no questions. He is so clear that people don't have any doubts left. Thank you, Mr. Batra.
I won't really necessarily give myself that credit, but it may be also that I was so confusing that.
No, your topic was obviously very technical, so it required a lot of attention to even understand that. And one can understand. But I've been listening to you so many times over the years, so we always come back enriched with better understanding of whatever you're talking about.
That's very kind of you. I look forward to hearing yours.
Yeah, I am going to cover a very beaten up topic in a way, but it's like a bad penny that keeps coming back. And that is the issue of provident fund dues and the priority and ranking under insolvency. Okay. A few things before. Okay, I want to keep my session highly interactive. So it's open for questions and comments right throughout. I have a presentation which I will try to cover very fast. I'm going to basically focus on 2 acts, 2 judgments of the Supreme Court. The first one, 2011 judgment in the PF Commissioner versus official liquidator of Escape Pharma. That will be one which will be slightly dealt in detail. And then a little look at the judgment in the ABG Shipyard case, which also deals with the provident fund issue, in addition to other issues. Okay, just let me share my screen. Okay. The first part of this today's session, we looked at judgments which were very technical in terms of their interpretation. It relied a lot on definitions, meanings of words, phrases, how they interact with provisions of statute, how each one and that which can change the meaning and interpretation and application of any provision of law. Now we are going to move into a little different way of how in relation to PF dues, the courts have interpreted provisions in what is called purposive interpretation, which is slightly different from the technical, in fact, quite a bit different. Okay. So I will take you through very briefly first to what is the report of the Joint Committee of Parliament on this subject, where it actually heard a representative of the EPFO, the Employees Provident Fund Organization, which is the trustee of the Employees Provident Fund, because the original draft bill of the IBC, when it was sent to the joint committee, it was in a format where the overriding preference, which was earlier available to Provident Fund use in the Companies Act and other rules, had not, that priority had not been kept, maybe because of the way it was drafted. And so the EPFO made a representation that the Provident Fund scheme and the EPFO Act, the objectives behind that, the purpose of that act, and what it seeks to achieve requires that the priority given to PF dues under the Provident Fund Act itself, under Section 11 primarily, need to be maintained even during the insolvency proceedings under IBC. And they also drew the attention of the committee to various judgments, prior judgments of the Supreme Court. The committee examined these representations and accepted them in toto. Okay, basically, and said that PF, Provident Fund, Pension Fund, Gratuity Fund, which provide a social safety net to the workmen and employees, need to be secured in the event of liquidation. These are the words from the report. Okay, secured means that they need to be, and the same priority and ranking which they enjoyed prior to IBC should continue even under the IBC. And that's how they modified certain sections of the Act. Primarily Section 36, subsection 4, which says that following shall not be included in the liquidation estate assets and shall not be used for recovery. Very, very mandatory provisions. Shall not be included, shall not be used for recovery. And what are those? That is basically assets owned by a third party, which are in possession of the corporate debtor, including assets held in trust for any third party, and all sums due to any workman or employee from the Provident Fund, the Pension Fund, and Gratuity Fund. Now, the subclause 3 here of 36 subsection 4A could have been drafted a little different, because the usage of the word from has confused many people. And one of the commonly misunderstood meaning is that it is from that fund where the money is already deposited. Now, if one refers to the first case of Provident Fund under IBC, which was the pioneer, the one in NCRT Mumbai, Precision Fastens, then that would clarify that that which is already deposited in another account is no longer your asset. So that obviously that is not what is being meant when it says from the fund. Now the word fund has been used in IBC and even in the PF Act with a small f and a capital F, and they do have slightly different meaning. Okay, when it is used with the capital F, it means a specific fund which is being referred to, which is the one which is administered by the PFO, or if it is an exempted fund, then by the company itself. Now, even exempted funds under the PF Act, when they say that company can administer them, they are never part of the company's balance sheet, the employer's balance sheet. They are always like a trustee, separate trust. The company has the right to nominate members on the trust, etc., but does not have a right to take back even 1 rupee from that fund. Okay, so it's never an asset of the company. So this is the section which is what is important for us now. But then now we are going back to pre-IBC just to understand that what is the purpose or the thinking behind placing provident funds dues at such a what you call super priority level. So if you look at this is possibly the best judgment which is there in terms of the detail in which it goes. That is PF Commissioner versus OL of SK Pharma of 2011. In some of these paragraph numbers I have given here, in 22 they say the EPF Act is a social welfare legislation. intended to protect the interest of a weaker section of society. Now, these things are important because even as they come to later in the judgment, they say that even when there is a conflict between the two, then when it comes to Provident Fund and issues relating to Provident Fund or some such thing, then a purposive interpretation which takes forward the concept of justice should be interpreted rather than the very technical or literal meaning. And that in this para, that's what they say at the end. A legislation made for their benefit, that means the benefit of workmen and employees, must receive a liberal and purposive interpretation, keeping in view the directive principles of state policy contained in Articles 38 and 43 of the Constitution. Now, this is where the power to interpret in this manner is coming from. Okay. They refer to a prior judgment of 1979 in which one of the sections of the PF Act was challenged, the constitutionality, section 14B, which deals with damages, and where in one of the paragraphs they say each word, phrase, or sentence of a provision of law is to be considered in the light of the general purpose of the act itself and not a bare mechanical reading. They refer to this, the amendments that were made in 1973, where section 11 was amended primarily to bring in one, the employer dues also within the ambit of priority dues, that means the dues of the employer's contribution, and also to create the charge, first charge on the assets in all the dues payable by the employer as a first charge. In para 38 is when they talk of that if there are two special enactments and they seem to be in conflict, and you don't know which one gives overriding effect to other. Okay, one of the rules later overrides former, but not necessarily all the time, and that has been held in across many judgments. Then the court is required to consider the purpose and the policy underlying the two acts. Now, this is how they have gone on to say that irrespective of whatever amendments happen or new laws come in, because the purpose of the EPF Act is, let's say, they have not used this word, but so noble or in favor of the weaker section of society. So in every interpretation when it comes to conflict should be where it advances the objective of that act, that is the PF Act. And again, the same thing, when a conflict has to be resolved by reference to the purpose and policy underlying the two enactments. Now we come to something with, and this is useful because this basically tells why section 11 was introduced and what really is the background behind it. And this is the statement of objects and reasons when the amendment was made. Now, in that, there is this para which says a provision is being made for treating the entire amount of, now these are the words very important, arrears of Provident Fund dues. Now, this is where they have used the right wording. Unfortunately, in the act, when it came in, it said from the Provident Fund. But basically what they're meaning is arrears. That means those which have not yet been deposited. And that is what is the entire thing about. The charge is created for arrears, not for what is already deposited, because then there is no need to create charge. It's no longer the asset of the company. Section 11, subsection 2 of the PF Act, the words all other debts, the court has gone on to say that it includes the debt to secured creditors. The confusion was that even in the Companies Act, under winding of 529, 529A, etc., after amendments, and now under IBC, in the first under section 53, you will find the words used secured creditors and workmen dues. Okay, they are pari passu. Now, in this judgment and others, they have said, okay, that workmen dues is not the same thing as PF dues. PF dues, because of a very special enactment, have overriding effect. So all the arrears of PF dues, and because that is what the Act object states, will be above all other debts, which include the debts of secured creditors, which means that they also include the workmen dues, and which implies that when you are calculating this pari passu ratio between secured creditors and workmen dues for, how they will be distributed, the workmen dues will exclude the provident fund areas because they have to be paid above. Okay. Similar again, now the latest judgment, April 2022, Sunil Jain versus Sundaresh Bhatt. This is the ABJ shipyard case. In para 13, they are talking of dues of the workmen or employees on account of provident fund, gratuity, and pension are concerned. They shall be governed by section 36, subsection 4 of the IBC. And 36.4, subclause 3 is missing there in that text. Specifically excludes all sums due to any workman from the PF fund, pension fund, etc. Therefore, section 53, subsection 1 of the IB code shall not be applicable to such dues which are to be treated outside the liquidation process. So, reiterating basically what they had said in SK Pharma judgment. In the same para, it is continued, section 36, subsection 4, clearly given outright protection to workmen dues under PF, gratuity, pension, which are not to be treated as liquidation estate, and the liquidator shall have no claim over such dues. Okay. And they are not to be used for recovery in liquidation. That's what the section says. Okay, a few questions just to, food for thought, not that it is for answering, but when a statutory trustee fails to perform their duty, its duties, should the beneficiaries be made to suffer? Now, the question I'm putting in the context of here, the statutory trustee is the EPFO. There is no choice among the members of that trust as to who their trustee shall be. It is by law. Okay. If the EPFO fails in its duties, and that would include monitoring whether the contributions to the PF fund are coming in time or not, taking action under the extremely wide powers that they have under the PF Act, and when they don't do such things, and also do not file claims or give proof of claim or substantiate the claims made during insolvency, then should the employees who are affected suffer? Okay, does it make, is that justice? Second, which I had referred to earlier, fund with a capital F and fund with a small f. Okay, how are they different? Third, okay, this is a bit controversial, and I'm trying to say this in the context of what has been observed, only to the extent of my observations, that too many IPs somehow seem to be going out of their way to see that the PF dues should not get the priority they have, or workmen's dues should not, and say EPF has not filed claims, so I will not accept it. Question is, first of all, what is the interest of the IP in doing such a thing? Why should they even think of doing it? They are supposed to be neutral. Okay. And if at all they have to be biased, it should be in favor of the weaker section, not those entities, financial creditors, let us say, who are supposed to have much more power, institutions mainly, and who themselves could be largely responsible, at least, of acts of omission, if not commission, in the insolvency process. I mean, in the company going to insolvency. And the last one, I think I had explained that an exempted fund is never an asset of the company because it doesn't form part of the balance sheet of the company. Just quoting from Justice Chandrachud, our current CGI, that very recently in the GNLU convocation, he had said that there continue to be laws as well as lack of regulations which push the marginalized deeper in the pockets of marginalization. What is legal is probably unjust, whereas what is just may not always be legal, etc., etc. Okay, so I have basically completed whatever is there from the Supreme Court angle. Okay, and I think we can go to questions and discussions now. And Mr. Batra is also here, so please specify which question you are asking. I will stop sharing now so that we can face each other. Yeah, Mr. Lonkar, question for me or for Mr. Batra?
I have questions for both of you, but since PF, dues you have just now, explained. So if you could kindly respond. You have stated that it's a social welfare legislation and it is about that, waterfall arrangement under section 53(1) of IBC, etc. in case of liquidation. For a company which is in CRP, and in the period prior to commencement of CRP, there have been delays in depositing those dues. Now, the EPFO raises a demand for paying interest and even damages for late payment of those dues. What should be the RP's stand? Whether he should pay that pre-CRP dues, considering what you have stated, that it's a special legislation, etc. If the liquidity permits, should he make the payments of those dues during the CRP period?
Okay, I will answer that question simply. First of all, if the liquidity had permitted, it's very unlikely that they would have remained unpaid. Okay, so which means that liquidity is an issue in general. Priority and ranking and time of payment are two different things. During CRP, any past payment is always frowned upon because it should and must necessarily be addressed only through the resolution plan and not ad hoc manner. Ransom creditors, India does not as such recognize it. There is a recent IBC order on something similar, though nothing, there was no real damage done. The entity involved was a public sector unit, but still IBBA, and rightly so, took the stand that this is not allowed. Whatever is pre-CRP due cannot be paid during CRP. Okay. But during CRP, what is accrued and payable? If you can pay it, obviously you must pay, because you are supposed to comply with all laws. All laws means all laws. There is no exemption there, to the extent that you can. So that part is, I think, to that extent I've answered. Now coming to the three types of claims, that is the principal amount due from the employee, which has been deducted by the employer, the amount due from the employer, the interest due for a delayed payment, and the fourth one is, of course, the damages under 14B. My own viewpoint is that 7A and 7Q, which is the principal amounts, and the interest are what go to the employee, okay, the member of the fund, and hence they form part of the principle of social net, etc. What goes under 14B, damages, it doesn't directly go to the in any way go to the members of the provident fund scheme, the employee is concerned. It is in way of a penalty to be recovered as damages, as a punitive measure on the employer, etc. Where would that fall? Would it be above 53? Probably not, though there is one particular judgment of NCLAT which says that it shall be, it has to be paid in full by the resolution applicant. In all debts include that, because they also have a charge. They are on the same footing. But are they same? Matter of opinion, I am not too sure of it. My own interpretation is just an opinion, is that claims under 14B are akin to government dues and would come under 53(1)(e) and not above 53. Yeah, you also had a question to Mr. Batra. You can ask.
Yeah, Mr. Batra has stated that the timelines is specified.
May I interrupt, sir? Actually, I'm a colleague of Mr. Batra. I'm from ILA. He's actually on a call right now.
Oh, okay. No issue. Just let us know when he is back, and we will take his questions. Yeah, any question to me or any comment? Okay, you can have your own opinion, question. Yes, Mr. Mishkar, go ahead.
Sir, thank you very much for explaining very clearly the various case laws and all that. So, but just for the sake of all of us, RPs as well as liquidators, so kindly summarize how, if there are EPF dues which have not been deposited by corporate debtor with the EPF authorities, or there are workmen dues, so how they should be treated during CIRP or under liquidation. What is your view on to that, sir?
Okay. Okay, all the dues of relating to provident fund, and the same applies to gratuity and pension fund. Okay, but let us stick to provident fund because it's actually slightly different from gratuity. So all dues relating to provident fund, which are falling in any one of these four buckets. Okay, employees contribution, employers contribution, delayed payment interest and damages relating to pre-CIRP period. That means they are become accrued and are unpaid as on the date of insolvency commencement, will have to be dealt with only through the resolution plan, with the caveat that here I am giving a bit of opinion that the 7A dues and 7Q dues will be above 53. Okay, that's my reading, that because that goes to the person concerned. Okay, that is their money, the money of the member. It's not the money of the trust. Now, trust as an administrator is also got the power to levy damages under 14B. So my opinion is that it goes under 53(1)(e). I may not be right, but that is what I would, if it was my case, I would deal with it that way. Now, during CIRP, is again a matter of cash flow. If these are dues to be paid and you have the money to pay them, please do. If you don't have the money to pay them, they become CIRP cost automatically. So, and in this case, not even CIRP, they go above CIRP. So PFT. So there's no difference between pre and post except in terms of disbursement. Okay, we'll use that word again. Okay, of how it is done. Other than that, they are same. Okay. Yeah, Mr. Batra is back. Mr. Lonkar, you can ask your question.
Yeah, but before I pose the question to Mr. Batra, you have stated there is no distinction between pre and post CRP dues. So again,
in terms of ranking and priority, not disbursement. Yes, that's different. Actual payment, pre CRP dues, I would say that RP cannot pay it when there are other dues also to be paid. Better to wait. Why do that? But during CRP, if the cash flow allows you, and because you have to comply with all laws, and the EPF Act is one of the most stringent laws. It is not used, but actually they have got powers of arrest. Okay, if you don't pay, the directors can be arrested. Unfortunately, if they had done their job, we wouldn't be discussing these judgments here. But during CIRP, if you have the money, you pay. Otherwise, record it in your COC minutes that why you are not paying. Okay, protect yourself.
And one more question, if any employee is, retiring during CRP and he has served the company for long, maybe 20, 25 years. So what about the payment of his gratuity, which basically pertain to the service, prior to the commencement of CRP, whether that gratuity amount should also be paid if the cash flow permits?
You have asked a very difficult question. And I think till today, nobody has found an answer to this. But I have a viewpoint, not an answer. Okay, just a viewpoint. Gratuity is payable on severance by retirement or death or leaving the company after a certain number of years. So that is a payment date. But gratuity is accrued over time. It's getting accrued, right? After you complete 5 years or whatever the rules are in that company, then you start accruing your gratuity. It may be funded. Okay, if it is a funded gratuity, then absolutely no problem. If it is the LIC superannuation fund or gratuity fund might have it, you just take it. If it is unfunded, that's when the problem comes. How do you treat that? My opinion is that all the gratuity which accrued in the name of that person up to the insolvency commencement date is prior claim, and that which has accrued after, okay, it could be just a few months or whatever, is part of that. Now, as far as the Gratuity Act is concerned, it's not on the same footing as the PF Act. PF is very clear. Everybody over the years has been clear that it is, super priority. Gratuity can even be stopped by the employer. That power is there in the act itself, which means that while PF is to provide for the family of the employee after the means of earning have stopped, gratuity is in the nature of a thank you for service. So very different levels at which they have to be looked at. Both are social welfare, but one is like, mandatory. There's no discussions left. Whereas gratuity comes a little lower. Where exactly does it come in? And not too many judgments on that I am aware of. So I can't give an answer on that immediately. But I think maybe Mr. Batra can. He knows better. And you can ask your question to Mr. Batra also. He has a question for you.
Maybe if I can just, do a follow-up on what you just mentioned. And I think, and I'm complete in agreement with you, Raviji, on what you say. I want to step back a little bit and treat this issue a little bit more fundamentally. Forget it is PF or forget it is gratuity for a moment. What is an IBC? What is an insolvency process anywhere in the world, especially a creditor and control regime like we have in India? What it really means is that the creditors contribute their assets in a common kitty, and then a body, institutionalized body called Committee of Creditors, decides the fate of the enterprise, whether it needs to be resolved by way of a resolution plan or it needs to be liquidated. And if it is to be resolved by way of a resolution plan, then the distribution of the proceeds from that common kitty have to be made in accordance with certain established principles, which are the waterfall mechanism. That is one, which in a way therefore says that all the creditors, not just the financial creditors, all the creditors are expected to contribute whatever their dues are or assets are in a common kitty, and then leave it for the resolution process to determine how they have to be distributed. That's the fundamental principle. Now, how that gets articulated and implemented depends on the other fundamental principles and those principles that may be peculiar to that particular law. Now, when I talk of the peculiarity of the law, it is also very clear that in the Indian context in particular, you have to balance it with the other statutory provisions that operate in the orbit of the insolvency system. They are not in exclusion to the other, they are inclusive. So the distribution has to be while keeping in mind the other legislations, in particular those that create social obligations, or those are for the society at large, or those that may be humanitarian, because the principles of insolvency law also say that you have to, insolvency is not just a commercial or economic law. It also has elements of social, humanitarian, and other principles. Like, for example, why is it that in the individual insolvency law, where you have to contribute your all the jewelry, the religious, those jewelries or ornament that have a religious significance are excluded? Why are they excluded? They're excluded because these principles, these issues have to be also kept in mind while you reconcile the fundamental economic principles of insolvency. They don't operate in isolation. Similarly, the other social principles, which may not be embedded in the insolvency law so unequivocally, if I may say, you have to draw from the other statutory provisions, some of which you if I may say, Raviji, very eloquently mentioned in your presentation about, whether it's the PF or the gratuity part. The other is the fact that the committee of creditors acts in a trust, as a trustee of those creditors which may not be part of the committee of creditors, and thus the decision making by the committee of creditors. And therefore, the committee of creditors has a duty of care towards these creditors also, who have contributed to the kitty, but who may not be part of the decision making, or whom the statute may not have given the responsibility to decide how they will get paid, but has left it to the other members of the committee of creditors. Now, I know what I'm talking about is more very fundamental and a more macro issue, but these dots do get connected by various judgments that you cited, various provisions of the code that you cited, which clearly mention three things, in my view, as a distillation of the interpretation and the application of these various set of provisions. And why I say this distillation is because insolvency law, remember, is considered as the mother of civil laws. While it has a superior place in the scheme of things, but it has about 100 laws that operate in its orbit. Some come near it at a particular stage of the insolvency process, some move away, but they remain in the orbit. They can't be ignored. And it is not only because there is an obligation by the RP to comply with the law. Even IBC is a law for that matter. But it is because of the following three reasons. That there is a fine line that those dues, whatever those dues may be, which become due and payable during the CIP process, have to be paid as CIP cost. If you have cash flows or liquidity, you will pay it during the process, or you will include it as a CIP cost to be paid ahead of other creditors. There's no problem about that. Now, for those dues that may have become due and payable before the insolvency commencement date, but may not have been paid, one will have to file a claim for that. But your right to receive those may not necessarily be dependent on the plan being approved. In particular, in respect of those dues which are not even the assets of the corporate debtor, and they were being held in trust by the corporate debtor. So I can't refuse to pay you something which is your own asset. So if you see the definition of section 18 also, which talks about what is it that the RP can claw back, can take possession of. It very clearly says those assets which are not, you can't take back those assets which are owned by the third party, except if you are in possession, right? And that status quo will be maintained only till such time the moratorium is lifted. After the moratorium, it can go back, unless of course the parties unilaterally, bilaterally agree that okay, you can continue. Now, in this case, if the intent of that party is very clear that this is my asset lying with you, section 14 will not come in the way, because there is no intent, or it cannot so be the case that you will continue to hold those assets even after the plan is approved. It is an asset of somebody which will have to go back to the assets. And if the cash flow permits, you have to do it. You have to pay. And you will see there are many instances, and not just because of the fact that there's a fear of the law catching up with you, but because of this very principle also, which is recognized in section 36A as well, very clearly, that even when you are formulating the liquidation estate, these have to be excluded. You have to keep them apart. And that's the reason for that is that is not your asset. It's not, you can't treat it as a part of the corporate debtor's asset. So therefore, the first issue is it's not your asset. You're holding it in trust. If you have the liquidity, you pay it, or you pay it in the first instance possible. Right? Now, the second issue is that the gratuity. As far as the gratuity is concerned, I am in complete agreement with Dr. Ravi mentioned. We don't have a clear-cut judgment on this, which could really answer the question that Ravi, that you raised. But I was talking about Ravi Lumka, that this is something which again is not a charity. This is not something which you can say, oh, fine, I'll take the liberty of reducing it as a part of the plan. The COC can't say, right? This stands on an absolutely different footing. This is not a commercial contract where you had agreed to give something as a loan, knowing fully the risks that are associated with it, knowing fully that you may get paid, you may not get paid, and in the event of insolvency, there may be a higher cut involved, right? Now, while in the case of a gratuity, otherwise there is an inherent trust that is reposed that I have served you for X number of years and I will not be shortchanged. So I would go to even to the extent of saying that
अश्विनी conference चल रही है जरा
I would
15 मिनट में खत्म हो जाएगी
उमेश म्यूट करना पड़ेगा आपको आप अनम्यूटेड हैं तो I would say that even during the CIRP, if this amount is available to be paid, it should be paid. No possible person can have any objection to that. This is not a financial creditor asking for his debt to be paid in priority to the debt of the other financial creditors or the other creditors. Now, while of course I do understand they are operational creditors, even the employees are operational creditors, but you have to clearly bring out a fine distinction, and I'm hoping that at some point in time there'll be a judgment to that effect. And the third principle, which is very, very clear also, though, we all know 238 overrides all other provisions of the Act, but only if it is inconsistent with the provisions of the code, that it stands in the way of achieving the objectives of the code, that a resolution or a liquidation in order to maximize the value of the assets of the copy data. So I don't see how the PF or the gratuity, etc., comes in the way of Section 238 and can be seen to be something which is contrary. Number two, also the principle of which law will prevail. If you see, the Supreme Court judgments are quite clear on this, that wherever the non-obstante clauses exist in more than one statute, the non-obstante clause in the special statute will prevail over the non-obstante clause in an ordinary statute. But wherever there's a non-obstante clause in both the special statutes, then the law is very clear that the subsequent statute will prevail. The non-obstante clause with the subsequent statute will prevail, because the legislature has taken into consideration the non-obstante clause in the other special statutes and yet chosen to incorporate that non-obstante clause in the subsequent statute. Therefore, the intent is that it overrides. So to that extent, yes, I agree, it overrides, the IBC overrides, but it is a 238. 238 overriding is conditional. It is not that it overrides in all other respects. It is only if there is something which is contrary. It very clearly says, so it will fall within the objection, and there is one judgment of NCLT's very recent judgment, I'm forgetting the name of that judgment very clearly, which discusses 238 in that context. And of course, we know Gujarat Urja also discusses 238 as to what is the overriding effect of 238, which is very clear that it really means that if there is an ipso facto clause, you can't use that. Ipso facto clause would mean that there is an insolvency trigger point for insolvency or termination of the contract on the ground of insolvency, that will be overridden. But it doesn't mean that if you are defaulting on the other provision of the contract, that cannot be terminated during the IBC. So these exceptions are very fine exceptions which are carved out. To sum up, I would say I'm extremely sorry for the rather longish answer, but this is really something which has been bothering me also, and I'm hoping that at some point in time we get more clarity on this issue. I do believe that we need to really pay gratuity and PF if the funds permit, and if the funds don't permit at that point in time, the COC has an obligation, the resolution applicant has an obligation to pay all these dues in priority, treating them unilaterally on its own as CIP costs. And that is the sign of a healthy market, a mature market, a market that believes in having a sustainable insolvency system and not looking at short-term gains, which is what in many cases we have seen. And Noida case, for that example, is also an eagerness of the market to sort of receive resolutions at any cost. What we don't realize is that these costs that we are escaping at this point in time will come back to haunt us. Because there'll be an unrest in the society, unrest in the government, unrest in the department. They will see this is not really, you need to balance the interest of the stakeholders. So I do hope that the resolution applicants are far more mature see this as long-term solutions, not just as short-term solutions, because they will be very disruptive in the midterm.
Thank you, Sumant, for your very comprehensive analysis. You have mentioned both PF as well as gratuity. Again, just for the sake of clarification, so that there is no confusion. So, in your view, during the CRP period also, the PF dues for the period prior to the commencement of CRP and the interest, etc., can be paid during the CRP period.
Absolutely. I will say, on the basis of the reasoning that was given by Ravi, as also my understanding of Section 238 and the various provisions of the code and the principles of insolvency, yes, I do believe that they can be. And no possible creditor can have any complaints with that.
Okay.
If I may add, there, just so that we are okay, there is one thing called the law and priority. Absolutely, there is no doubt that it has to be paid. But also we need to be aware of the procedural aspects and the fallout, if any, on the decision being questioned. So unless you are very sure as an RP that there is sufficient money to take care of every cost that is incurred during CRP and paid in full, be careful about paying anything which is of prior date. Obviously, it is priority; it will be paid. The statutory priority is established by way of statute as well as Supreme Court. But be careful, because recent DC judgment, we have to take that into account also, that anything which is okay. Let me put it this way: the code, the regulations, and the system recognizes commercial wisdom of COC, but not of the RP. So let me put in that.
Therefore, the RP has to act in good faith. It has to act on the best advice, while COC acts on its own advice and its own commercial wisdom, whether it is a borrowed wisdom or based on the advice or its own wisdom. But the RP has to act on the basis of expert advice. So therefore, any such decision should be backed by expert legal advice. It should be obtained so that you can show your bona fide that you were diligent, you sought expert advice. This is the advice that you received, and you acted on that advice. And there was no intention to favor any particular party or everything. And I also would like to amplify that point that you made, Ravi, that you can't pay them at the cost of compromising the resolution process. If you don't have adequate funds, or the funds are not adequate enough to see the resolution process through, then you would be fully justified to say that while I recognize that you need to be paid, but I don't have adequate funds. And whatever I have, I can't just pay to you and let the CRP go down the drain. So that balance has to be drawn. But that's also a commercial decision, because they are applying the economic principles.
But just a counterpoint, because so far as pre-CRP dues are concerned, the law is clear, according to me. So though what you have stated also makes sense, and what Mr. Ganti has also stated, that it's a welfare legislation, and there are a number of judgments which support that those dues are above even what is envisaged under Section 53, etc. But being pre-CRP dues, do you think it would still be prudent to make the payment, subject, of course, that the cash flow permits? Should those prior period, PF dues be paid?
Yeah, Mr. Lonkar, I think we answered that 3-4 times, that you look at the entire thing. If you can run the process, pay every single due that has arisen during the CRP period and still have money left for pre-CRP dues, then take the risk. But my prudent advice would be not legal. This is just prudent, good, to be on the right side of, disciplinary aspects.
That is why I posed this.
Don't, see, it is priority. It is going to be paid first. It has to be paid first. Wait for it if it has not been paid till now, but continue to pay everything which is current. Now, I have not come across any insolvency situation, not that I am aware of, where there was money left over to pay pre-CRP dues. Then the question would come, why did it get into insolvency in the first place? Oh, hota nahi hai. Okay. So one would say, yeah, be careful about PCRP dues. Definitely include them in your IM, etc. It will have its priority. But as far as actual payment is concerned during CRP, best
I
not
have
to
a
touch CRP deals.
I have a question for Sumant, sir.
Yes, please.
Sir, you have very nicely explained all the case laws, including rainbow paper. So my humble request to you to kindly summarize what and how an RP should treat in the light of rainbow papers, the dues of sales tax department now.
See,
Mr. Batra, if you just,
Sure.
before you give the answer, just a couple of lines that I want to add. I used to say this, that rainbow paper judgment is largely correct but incomplete.
And that's
Because it has not taken into consideration, in my humble opinion, section 53 subsection 1E.
Yeah.
So just as an example, if I give you, okay, that you have been given the job of separating, let's say, fruits and vegetables into two different barrels. You get all mixed up in baggages. So there is fruits, there is vegetables, you keep putting. Then I put a third barrel, which says apples.
Yeah.
Now you can put a fruit, when you take out an apple, it can go into the fruit barrel as well as the apple barrel. Where will it go?
Yeah.
Now the statutory interpretation is very clear. Specific entry, overhead general entry. So there is 53(1)(e) which says government dues. It includes all government dues. It doesn't say secured and unsecured. Everything is included there.
I agree with you. So now,
Yeah,
the way I
go ahead.
put it is,
I'm sorry.
Ramesh, that you see, the judgment I also said in my comments is been overplayed, and it's largely because of the fact that it doesn't really explain the logic why it has been mentioned in such a way, and also doesn't discuss some of the pros and cons or other aspects. That's fine. I think that part will get corrected in the judgment, either in the review or also, if I may say, in another judgment that is pending before the Supreme Court, where the intercept priorities of first charge holders is under consideration. That's from Enclave judgment, where they've held that once the secured creditor relinquishes the security interest to the liquidation estate, it loses priority, which is ridiculous. And I think that will get corrected. And I'm very sure when that part is discussed by the Supreme Court in the judgment, they will deal with rainbow and they will distinguish rainbow and clarify rainbow. So I'm actually very hopeful that even if rainbow in review doesn't get corrected, it will get corrected in that judgment. But the way your answer, how you should treat it, is exactly how you've been doing in the past. So as far as statute dues are concerned, I think the only caution that you need to apply is that even if no claim is filed, but if it is recognized in your books, you please admit it as a claim, verify it as a claim. And even if it is not admitted in your books, but if there is a litigation pending, a demand pending, a recovery proceeding pending, mentioned in the information memorandum as very clearly. And if there is a contingent liability that's coming in, give a value to that contingent liability and put it there. That is as far as the treatment is concerned. Now, as far as how a resolution applicant should treat it, that is, frankly speaking, none of RP's business any which ways, because that's
my question is resolution professional, not RA.
मैं RP की बात कर रहा हूँ कि RP is not supposed to decide how the RA treats the various creditors in the resolution plan. That is the obligation of the COC under section 30 subsection 4. They have to ensure that it is in accordance with the waterfall mechanism, right? However, since you are a manager of the process, you have to assist. Therefore, you of course need to know what the law is, and the law is as follows, based on that judgment also, and as it was even earlier, that if a statutory creditor is an operational creditor, it will have to be treated as an operational creditor. But if an operational creditor is a secured creditor, then it will be treated as a separate class within the operational creditor as a secured creditor, which means that if there are any dues that are liquidation value available after the secured creditors, financial creditors have been paid, then the operational creditor will get paid from the residual, if at all, from the residual that is lying in that receipt, because they have a charge on those assets. As far as now, the only tricky part is that supposingly that operational debt, or those assets, and I was giving an example also. Now, supposing the income tax authority had a demand and the demand is crystallized, and they, by way of a statutory operation of law, by fiction of law, get a charge on that amount that is recoverable or receivable, and if it is determined, if it is not determined, it's a different matter. If it is determined and they have filed that charge with CERSAI to say that we as income tax authority have a paru passu, have a charge on this asset, then that priority on that particular asset will be determined by the rules of priority under the CERSAI rule, right? That will depend on the facts of the case, whether that charge is, because if you see, the security interest is very clearly defined in the law. Although in terms of the priorities are not defined as to how the priority will be proven by the secured creditor, but it is inherent, because if you see the forms, it clearly mentions your security interest and the charge, and therefore you can mention in that what is the status of the charge, whether it is secondary, pari passu, first charge, or whatever it is. But in liquidation process, there is a very clear way in which the priority has to be determined. It clearly says as per the charge file registered with CERSAI and ROC, which is not mentioned in the resolution process regulations though, but in liquidation it is mentioned. So the intention of the legislature is very clear that you have to prove your charge for the purpose of distribution based on how you gave notice to the public. You can't just say, I have a statute chart under the Income Tax Act, the whole world knows it, it does not. Because CERSAI rules very clearly say you have to give notice to the public, and that notice is priorities are determined by the date and time of the notice. So if you have given subsequent to the secured creditors having filed their charge, you have registered your charge, then your charge is any which is secondary, right? So to answer your question in a sum up, this judgment does not create any issue as far as that treatment is concerned by the RP. The only problem that it creates is it says if the resolution plan doesn't provide for the statutory dues, payment or dues, you have to liquidate the company, right? Now, if you have to say that I have to comply with the judgment and the resolution plan doesn't provide for those dues, entire dues, that creates a problem for you, right? But for as an RP only, then what you're required to do is only point out that the judgment says this, law says this provides this. In my opinion, you would still not be able to say that the plan is not compliant of the code because it doesn't really breach the provisions of the code. Because the judgment doesn't say that by not paying the statutory dues, you are violating such and such provision of the code. Yes. Although I'm hoping that in the next, after the Supreme Court reopens, this judgment will get corrected because one of the banks has filed it. That judge has retired. So we don't know who this will go before. But I'm very confident. And I'm also very confident that in the event the judgment doesn't get corrected, the government will step in. And in December, you will find a correction being made in the law. Amendment being made in the law to address this in the event the bank fails to persuade the Supreme Court to rectify it.
And post this judgment, without naming this judgment, even IBBI has said that the IBBI has not been represented and there are certain decisions where...
Yeah, so that is a general notification that they have sent out to the RPs that they should inform,
yes.
IBBI, wherever there is an implication on the law.
Yes.
So that the IBB can read. Now, that's of course not really practically possible to follow in every case because otherwise RP to chance lega nahi, wo to har ek mein inform kar dega.
Yeah.
And they will have to take a conscious call whether they want to or not, but at least it's okay because these two judgments have caused a huge amount of damage. And unfortunately, in both the cases, the law officer of the country was representing the other side, right? So IBBI never really had the opportunity to be able to represent their view. That has caused a bit of a problem also because the government can't file for review of this because the law officer was representing them, and the other side is the state government. So, but fortunately, a bank has come forward to file the review, and hopefully, we will see the correction being made.
Thank you.
May I ask my question to Batra sir?
Yes, please.
Okay. Thank you, sir. So, sir, the judgment of the Supreme Court is the law of the land. If I take this view, then if I am not following the rainbow judgment, then a plan which is not compliant with rainbow judgment is not as per the provisions of the law of the land. Now, where I come from, why I'm saying this? Sir, at Mumbai bench, I found that a couple of resolution plans have been sent. So the moment the issue of discussion of the resolution plan came up, the bench inquired whether the plan was compliant with rainbow. So when the bench was informed it was not, so the bench sent back the resolution plan for the reconsideration of the COC. So basically,
On the
what
basis of
is
rainbow judgment.
yes, yes, yes,
Yeah.
sir.
So
At Mumbai bench.
yeah, I understand that. So let me just respond to you. Your question is this way. As far as the NCLT is concerned, I do understand that the lawyers assisting them would have said that this is the law, and therefore you're required to send it back. But if there would be a lawyer on the other side who would be able to persuade the NCLT to say that Ghanshyam Mishra was not considered, it is distinguishable on the basis of Ghanshyam Mishra. There are a number of other judgments which say so, and therefore there is a contrarian view. It is quite possible that they would have been persuaded to distinguish rainbow. But having said that, I find no fault in the NCLT order, because the NCLT might do whatever they need to do. But I do not still see how the RP can say that the resolution plan is not compliant, because it doesn't really require for servicing of the entire dues of the statutory creditor, because this is a question of interpretation, right? No, and I do believe that if I am the RP, I would say that this is what the statute says, this is what Ghanshyam Mishra says, this is what 5 other judgments of Supreme Court say, this is what Rainbow says, and therefore I am leaving this matter. I'm placing this resolution plan before the COC with these observations. There is a judgment of NCLAT which has never been set aside. I think it was in Benani, if I'm not mistaken, a long time back, which says that the RP can't refuse to present the plan before the COC at all. The RP can't take the decision to say, I will not present it before the COC. RP is nobody to be the final authority that this plan is compliant or not compliant. His duty is only to place before the COC with his observations, right? So if I would be a lawyer, I would advise that stop short of saying it is non-compliant. You articulate it in such a way where you say that this is one view possible, this is one view possible, and I place it before the COC for consideration, shift the ball in the COC court. And I would not say that it is non-compliant on the basis of that. But I would also not say it is compliant. I would just put in my observations that based on this, these are the diverse or divergent views that are possible. I'm placing it with my comments. Do that till such time you get clarity of it, is how I would say. But I would not say I will reject this plan or say that I find this plan to be non-compliant of the provisions of the code. At best, you may say that this doesn't meet the requirements of these 2 paragraphs of the judgment, but if you see it in the light of Ghanshyam Mishra or other judgments, these are 5, 6 judgments, it meets the compliance. And you have to see that the Rainbow doesn't overrules the other judgment. It has not been considered Ghanshyam Mishra. It has not even considered some of the other judgments. That is the basic flaw in the judgment. So I would not say that anybody should take the risk of holding the plan to be non-compliant on the basis of this. We all know that is a transition issue. We know that is a temporary phase. It will get corrected. And even if it doesn't, nobody should really take the risk of saying it is non-compliant. Find a tactful way of keeping it alive.
Thank you, sir. Thank you. Highly obliged.
Anu, I think it's 6:06.
Yes, sir. Thank you so much to both the faculties for taking the session. It was very detailed as well as informative. Thank you. Thank you to all the participants also for listening, and thank you. Thank you, everyone.
Thank you so much once
Thank
again.
you.
CSI for
Thank you all.
inviting us, and thank you so much for
Thank you, sir. Thank you. Highly obliged.
As my co-panelists, and also for all of you to be here on this evening to hear us. Thank you so much.
Thank you to ISCIS, sir.
Thank you to all. Thank you. Bye.